Hey there, everyone. It's Rob Ryder on February 16th, 2014, which would be a Sunday. We're going to talk more about abstracts and administration, as in court administration. Because you find certain things when you look in the rules of administration of a court, such as Rule 8112. Claims by clients against attorneys. Attorneys are officers of Michigan's one court of justice and are subject to the summary jurisdiction of the court. The circuit court of the county in which the attorney resides or maintains an office has jurisdiction on verified written complaint of a client. Isn't that interesting? You don't need to go to these things they tell you about, the review board and that kind of stuff. You could take it to the circuit court of the county. So more about that in a second. Rob Ryder, court of record at AOL.com is my email address, and phone number 616-712-6179. So, circuit court of the county. Just real quick, what does that look like? Well, this is my certificate of certified copy of record of birth, and it's from the clerk of the county of Bay and the circuit court thereof. The same being a court of record, having a seal, do hereby certify, right? So Stephen Toth is what we would commonly call today the county clerk here in Michigan. This was back ancient times, 1958. But what they had back then was a circuit court of Bay County. Now we also have judicial circuits, and there's a circuit court for the judicial circuit. That seems to be the state court. This is like the county court. This is, and the only thing it says about every place having a county or having a court in the county is the probate court. It says one of the laws that every county will have a probate court, although some may be a division having 2 or 3 counties, but they have a probate court. And so this says Circuit Court of Bay County. It doesn't say Circuit Court of the 16th Judicial Circuit. It says Circuit Court of Bay County. So there must be a difference. The point being, the clerk of this court is the person you would think of as the Stephen Toth, clerk of the county of Bay. Not county clerk, clerk of the county, same person, different hat. Right? You want to go to them in the office of clerk of the county of Bay and the circuit court thereof. That's the clerk of the county court that I believe they're speaking of here. The circuit court of the county in which the attorney resides or maintains an office has jurisdiction on verified written complaint of a client. And same as a probate court. And this goes back to Jason, back a couple of years ago when he had a complaint against the recorder down in Georgia for tearing up his public record. He went to the probate court, said he wanted to put on a complaint, and they took him in the back and they took his complaint. Well, if you think about it, the county also has jurisdiction, at least in Michigan, over all the notaries. Every notary is commissioned by the county. And all attorneys are really, if they're nothing else, they're notaries. What else we got here? Okay, and after reasonable notice and hearing to enter an order for payment of money or for the performance of an act by the attorney by which law and justice may require. In other words, to make them give you the defense that you require. Such as the fact in a criminal matter, is there a sworn complaint? Is there an information? Is there an, what's the other one? You got informations and you have indictments. One or the other. In a civil matter, right? Is there a certificate of good standing for the plaintiff? What is the verified debt? What is it they're saying that they owe you? So, if they're not giving you these things, you can put a complaint in, verified complaint, to the circuit court of the county. Because attorneys are officers of the Michigan's one court of justice and are subject to the summary jurisdiction of the court. They're under the one court of justice, right? Attorneys are officers of the court, and they're always considered in court, and they better not bring fraud upon the court. Don't matter what they've been doing every day. When you point it out to the right people, things may change. All right. Hey, can you donate? If you can, I can certainly use it. It's coming that time again. PayPal account name is Ashley Rytlewski, ASHLEYRYTLEWSKI @gmail.com, and my snail mail, Robert Rytlewski, 10955 14 Mile Road, Rockford, Michigan. I did it again. 49341. Jeepers. Can't frickin' type anymore. Another interesting rule from the administrative rules of the courts: electronic filing of a citation. This rule applies to all civil infractions and misdemeanor actions initiated by Michigan Uniform Law Citation or Michigan Uniform Municipal Civil Infraction Citation, which I did a video on. This is basically a traffic ticket. That's all done online, and when they get done with it, there's a place where they're supposed to put their name. Citation, complaint, filing. A citation may be filed with the court either on paper or electronically. The filing of a citation constitutes the filing of a complaint. An electronic citation must contain all the information that would be required if the citation was filed on paper. A citation that contains the full name of the police officer or authorized local official who issued it will be deemed to have been signed pursuant to blah blah blah. Okay, the thing is, they don't put their full name, right? The full name has got a definition. If you don't know what it is, go look it up. Right? It's your given name and your surname. Not an initial and a surname, not trooper, abbreviation, TPR, P for Paul, Smith. No. The full name is Paul Smith. Doesn't matter that he's a trooper. Didn't ask for his job, asked for his full name. Not his position, not his office. A citation that contains the full name of the police officer will be deemed to have been signed pursuant to. But they don't do that, so it hasn't been signed. I forgot to put the last part on here. And since it isn't, the court isn't going to... If you make an issue of it, the court won't hear the case. What the court's going to want to do is dismiss with prejudice. And you're going to say that they're simulating the legal process. Well, that's, those are good things to know for the future. But what if you've already been in a case and they've taken your property or so forth? Well, we're going to go look at that. So, cancel. Just click that one smaller. Okay, so anyways, this is just to show you that, at least in Michigan, we have circuit courts of the county, of Bay County, and there should also be a circuit court for the judicial circuit. And the circuit court for the judicial circuit is the state court. The circuit court of the county of Bay is the county court. And the county court, I believe, is when you see the probate court, when you walk in the door, probate court, that's the county court. Alrighty, enough of that. Let's go on here. So what do we got next? I don't want to go... We'll get back into the administration in a second, but I wanted to go back over these abstracts a bit. I didn't do a very good job last time. What's an abstracted judgment? Is a written summary of a judgment which states how much money the losing defendant owes to the person who won the lawsuit. That would be the judgment creditor. The rate of interest to be paid, blah, 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 blah. The abstract is acknowledged and stamped so that it can be recorded and made official with the government. Again, I don't know what they mean by stamped. To me, it didn't say sealed with a court seal, or said stamped. And they mean a revenue stamp? That's what I think they mean, is the documentary stamp. The purpose of an abstracted judgment is to create a public record and create a lien or claim, if necessary, on the real estate. So it's this properly filled out abstracted judgment, which is the lien. That's the lien document, right? And so when you get a notice of lien, what you're asking for then is, where's the abstracted judgment? that's been filed with the court and recorded with the in the county where the real property is. If the loser does not pay the judgment voluntarily, the winner can force the sheriff's sale of the property to collect. That would be like, your foreclosure you go through. There are several problems to find the county where losers own real estate. Well, that isn't that hard. They know where your real estate is because your real estate's really the paper. And that real estate paper has been recorded in the Register of Deeds or county recorder's office or whatever they call it where you're at. Oh, the probability that there are secured loans, tax liens, or other judgments that come ahead of the judgment lien. Yeah, okay, it could be. The possibility that the loser debtor may go blah, blah, blah. But let's say there's a tax lien. Again, the tax is going to be for some minimal amount of money. Right? The amount of this claim is going to be for some minimal amount of money. If they swore to it. I don't think we're going to find properly filled out abstracts. We're finding notices, right? So if you've ever gotten a notice of lien from a court, go there, or from wherever, go there and ask them for the abstracted judgment. That is what the lien is. It's the abstracted judgment. In the United States, abstracted judgment is chiefly used in a technical sense to describe a document produced by a court which describes the judgment rendered in the case. Abstracted judgment is a clerical document containing a summary of the court proceedings which may be useful, though not conclusive. That's for criminal. In property law, civil, in some states such as Texas, an abstracted judgment is a specific type of document provided either by a court clerk or by an attorney, which is used to prove the judgment has been rendered. So I did a video some time ago on confessed judgments, and an attorney can do a confessed judgment. Right there, because they're a notary, they can basically sign off, I guess, say, yeah, confessed judgment. So it wouldn't have to necessarily go to the court. But there still has to be this document. If they're saying, somebody says they have a lien against your property, where's the document? The abstract may then be filed in another jurisdiction where it constitutes a notice of a judgment lien on a debtor's real property, thereby preventing the transfer of property until the judgment has been paid. This process described as Supreme Court, blah, 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 blah. Okay, we'll get back more into that in a second. Abstracted judgment as a lien on real property. You have obtained a judgment against someone, and now it's time to collect. How can you make sure you get paid? One simple way is to place a lien on the judgment debtor's real property. This can be done by filing an abstracted judgment in the county where the person's property is located. That means that this document, abstracted judgment, is the lien. You need to find the abstracted judgment. They're not saying how much it's for. They're just going to say there's a lien against your property, but they're not going to say how much it's for. Basically, it's a one-page document that states, blah, 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 blah. This is all stuff that's easy enough to find online. To have any valid effect, the abstracted judgment must be recorded in any county recorder's office in any county where it will become a public record. Right, so to me, it sounds like this doesn't have to be even in your county. It can be in any county. If you're living in one state and you were born in another state and they have birth documents in the other state and your body is considered land or real property, well, they could go record it in your birth county with the county court, right? Because this is being done in the county. The lowercase county recorder's office. To me, that's different than uppercase county recorder's office. This, who's the county recorder? Is it the registrar of probate? Somebody in a county court? The courts they seem to be hiding from us? I don't know. But so they look something. So this is like what a civil case looks like. Abstracted judgment. Right here. This is from California. Abstracted judgment, civil and small claims. That's what the form looks like. Blah, 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 right? Not a lot to it. The interesting thing is down here where it says seal, that's where the seal of the court goes, and certified by, the name of the clerk goes in this block here. The abstract issued on some date. So I showed this is a guide that comes from the Sacramento County Public Law Library, abstracted judgment, easy enough to find, don't need to send it to you. We'll just quickly read some of the highlights that we talked about before. You must take the form of the Superior Court that issued the judgment so that the court clerk can certify the document. All right, put the court seal on it. And then you need to take the certified copy from the court clerk, not certified as a certified copy, but certified true and correct by the court clerk to the county recorder's office. And they'll record the document. After recording, you have a lien against the property, right? That's what makes the lien. Recording that document is the lien. The abstract of judgment is the lien when it's recorded with the county recorder. You may file. So first you file, then record. First you file the abstract of judgment with the county courthouse, with the clerk of the court. The clerk will return the original to you with the court seal on it. Right, the big ass gold seal. Take the original certified abstract of judgment, at least 3 copies, to the recorder's office. And you're going to record the previously filed abstract of judgment. And if you are recording in another county, be sure that to check with the county recorder's office to determine the correct location for recording and recording fee. Right, so once you have this thing filed with the court, you can record it in any county that you believe that the defendant has property in. And then it says the county recorder will provide notice to the debtor that you have recorded the abstract of judgment. So if it's been properly recorded, then the county recorder is going to send you notice. But I don't believe any of us ever get proper notice that we have these. Now, I don't know that to be absolutely true. It could be IRS, you're getting one, but you don't know what to ask them for when you go down to, you get these federal liens on you. Well, okay, where's the abstract of judgment? Ask them. But the reason we may not be getting it, and I showed this last time, is, when you do the address for the defendant, and if you don't do it to the address that you have and you don't get the mail, well, they can say, well, we sent it to the defendant to his last known address. In fact, they're supposed to certify, put a certificate in after they get a default judgment, I think it is. They have to, the attorney for the opposing side has to put in a certificate of last known address. What address did he send the information to? And so 11 Main Street, number 22, what the hell does that mean? What is number 22? If it was an apartment building, it should say apartment 22, right? My thought is, if you don't have a box in your house with the number 22 on it, they're not going to put this mail in there. Or like in Rose's case, where she had an arrest warrant that had her street number, name, city, and all that shit's correct, state's correct, got a different zip code, -0000. Well, hell, that's going to the post office. That ain't going to her. It wasn't her zip code. Right? They're using different zip codes. We're not getting the mail. But nevertheless, you could still go down into your county if you're into some kind of foreclosure or something now, and hey, do you have any abstracts of judgments for me? And give them all the different ways you could have your name. For instance, who is the plaintiff, or who's the defendant on your foreclosure? Right, that name, because that isn't exactly how you do your name. And then Rytlewski, Robert Allen, or Rytlewski, Robert, or Robert Allen Rytlewski, or Robert A. Rytlewski, or Robert Rytlewski, or whatever it is, right? Rytlewski. Got any for Rytlewski? Let's look at those. We need to narrow down where our stuff is. The clerk will insert the seal and insert the date the abstract was certified, right? Now, the clerk has to certify. I certify. This is them attesting. This is them raising their hand under oath. This is a big deal to get a court clerk seal of the court seal, not the county, not the clerk's seal, the court seal. Looking for the court seal. All right, and if it's in there, well then that's the lien that we're talking about, or that they're talking about. Got a lien against you. What is it? It's called an abstracted judgment. Okay, well there's another type of abstracted judgment, and it's used in traffic cases. And it looks something like, well, let's see what it says here. This was Arizona. Title 28 is transportation. Got lots of great things in transportation we've already talked about in the last one. $5 license plates, $8 to register your car. But each magistrate, judge, or hearing officer of a court shall keep or cause to be kept a record of each traffic complaint or other legal form of traffic charge deposited with or presented to the court or its Traffic Violations Bureau. Keep a record of each official action by the court and its Traffic Violations Bureau in reference to each traffic complaint or other legal form of traffic charge deposited with or presented to the court or its Traffic Violations Bureau according to but not limited to a record of each conviction, forfeiture, bail, blah, 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 blah. Okay, so basically any court case goes through, they're supposed to keep a record of it. And then each magistrate of the court or clerk of the court of record in which the conviction or judgment was had or bail or deposit was forfeited shall prepare and immediately forward an abstract of the record of the court covering the case in which the person either was convicted, adjudicated, that would be like settled out of court, right? You agreed with the prosecutor, which is what most of us do. Forfeited bail. The person required to prepare the abstract shall certify that it's true and correct. Right? So again, court seal, going to have a court seal and certified by the court. Well, as it turns out, what's it going to have on there? Okay, first of all, it shall include the name and address of the party charged, the number, if any, of the driver's license, the registration number of the vehicle, nature of the offense or civil violation, yada, 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 the amount of the fine, so forth. So, Bobby in Arizona, because this is from Arizona, December of 2012, it's not 2013, 14, 15 months ago now, he had a traffic ticket. And we had done some stuff, and it didn't work, and he ended up paying it. Okay, just walk away from it. Boom. Well, so he calls because the thing is, this says it's going to be forwarded to the department, and the department ends up being the Department of Transportation. So he called the Department of Transportation and was talking to him, and they, so what's the court case? Yep, I'm looking at it. Yeah. And he said, well, I'd like to see the abstract of the court case. And the guy says, well, go to the court for that. And he says, I don't want to go to the court. I'm talking to you. It's supposed to be forwarded to you. I want to see the abstract of the court case. And so the guy said, okay, just a minute. And, it took him a while to come back. He said, oh, they must have made a mistake and they didn't send that to us. Well, the reason they didn't send it to him is because there was never a sworn complaint against Bob to start with, and this is all simulated legal process. No clerk's going to certify to that. Right? Like they told Handcuffed John at the district court in Virginia, nobody puts in a sworn complaint. Right? There are no sworn complaints. Well, you can't be charged for a crime unless there's a sworn complaint. That's what the state law says. They're taking this fake intermediate, this franchise court, and they're not, and they're not following the law, and now you can point to it. This is the wonderful thing. This is how you shut down the whole court, because we get a quo warranto against them for simulating the legal process. Because it ain't just one. It's not, one would be a mistake. Now, Bob's got another traffic ticket, and he's going to check on that. Well, the courts are closed Monday because it's a holiday. Check on it on Tuesday and see if that one's in there, right? One may be a mistake, two's a conspiracy. And just simply ask him, well, how many abstracts did you get today? Right? Because every day there's court cases going on, and we're talking about a state department over the whole state of Arizona. Well, how many abstracts did you get in today? How many traffic cases happen on a daily basis in Arizona? A couple hundred? At least. So every day they should be getting a couple of hundred of these in, even if it's 3-4 days later, because it just keeps rolling through, right? It's like a big snowball rolling. I wonder how many they got in. Well, we're going to find out. The department received the abstracts received under this section for inspection as required by law, right? It's a public record. I want to see it. That's really the simple thing. So you should, now in Michigan, it's not the Department of Transportation. We'll look in a second. It's supposed to be the Secretary of State. So call the Secretary of State, and they're going to say, well, what do you want to see it for? Well, I want to be sure it was done to make sure that there's no fraud being committed. Because if you don't have it, then the court committed fraud. And if you don't have it, then I've just made you aware that the court committed fraud, and you would be guilty of misprision of felony if you don't investigate. So go check it out now. And put them on the defensive. I mean, Bob got him to blink on Friday. Oh, I guess they didn't send it to us. The guy didn't know what to say. It took them 20 minutes to come back to tell him that. They had to really think about what to say. In Ohio, right, immediately forward to the Bureau of Motor Vehicles an abstract. Right, so in Ohio, it's called the Bureau of Motor Vehicles. Michigan is Secretary of State. Arizona, it's the Department of Transportation. In Washington, and this is the same in any state, you can get an abstract of your driving record. Right? So this would just be an abstract, a person's driving record, whenever possible, must include enumeration of motor vehicle accidents, which person was driving, including the total number of vehicles involved, whether the vehicle was legally parked, any reported convictions, forfeitures or bail, findings of an infraction was commenced. Right? So if you get a hold of this and it doesn't show any reported convictions and you've had tickets in the past, well, somebody's got something to answer for. Any reports of failure to appear in response to traffic citations, or failure to respond and notice of infraction served. Right? Because again, the thing with the traffic ticket I showed at the beginning for Michigan, even though it's an electronic traffic ticket, it has to have the policeman's full name on it, and they don't. They just have an initial. It's got Trooper, TPR, initial, last name. That isn't what it asks for. Well, it looks like we also have things called abstracts of convictions. Now, I haven't dug into that too deep, but just looking at some of the other things there are abstracts for, right? You got abstracts for title of property. Now, here's one. If you have a tax problem, right, you can go to the county treasurer shall, make upon request a transcript of any paper or record on file in the treasurer's office for the following fees. An abstract of taxes and any description of land, 25 cents per year. An abstract with statement of name and residence of taxpayers, 25 cents a year, right? So you should be able to go to the county treasurer. If they say you owe taxes, say, well, I want to have an abstract. Give me an abstract of the taxes I owe. Because this thing about any description of land, this is one of those things where we don't know until we go check what they mean by that, because there could be more than one description of your land, depending on the jurisdiction that it's in. Because there's only so much land, but there's multiple jurisdictions, one on top of the other, or, think about it. You got all these different jurisdictions, they all got geographical lines, but it's all on the same ground. So which description of land are we talking about? And this has going back to look at the plats and get the plat information. And Rose has been doing some really good research on that. Hope to have something on it pretty soon. But basically, it sounds like you got to go back to the plat and get your name on the plat. A system of abstracts in support of the validity and accuracy of the abstracts made and sold. So they're selling abstracts. That the abstractor, we got a person called the abstractor. Well, who the hell is he? Right? They got somebody holding an office called the abstractor. From each abstract made and sold. Well, who's selling abstracts? What are the abstracts of, and who are they selling them to? Each abstract shall have attached a certificate that all conveyances and other matters of record in the public offices of the county affecting the title to the property covered by the abstract are correctly set forth in the abstract, or certificate of lesser extent, blah, 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 blah. The certificate shall be signed, blank, county abstractor of some county, name of abstractor, name of county. That would be interesting. That would be a very interesting book to find. Who's the abstractor? Now, I asked this question a couple, 3 years ago when I was really, green at this and just going down and trying to ask questions, and they didn't want to tell me who the abstractor was. They didn't tell me who the abstractor was. It says it should be the Register of Deeds, but it's lowercase Register of Deeds, and I'm talking to the people at the uppercase Register of Deeds window, and they don't want to tell me who this abstractor is. And really, it's because it isn't in that office, I don't believe. It's in the court. Right, that's where the real registration of deeds is done, wherever the office of wherever they register titles is. So, okay. So here in Michigan, right, like I said, we would send the municipal judge or clerk of the court of record shall prepare and forward to the Secretary of State an abstract of the court record as follows. Really, we need to be talking to the lowercase Secretary of State's office. It's transportation in Arizona, Bureau of Motor Vehicles in Ohio, Secretary of State in Michigan. An abstract report required in this section shall be made on a form furnished by the Secretary of State. An abstract shall be certified by signature, stamp, or facsimile signature of the person required to prepare the abstract as correct. The abstract or report shall include all of the following: name and address, date of birth of the person charged, the number of persons operating driver's license, if any, the date and nature of the violation, the type of vehicle driven, the date of the conviction, finding, forfeiture, judgment, whether bail was forfeited, any license restriction, vehicle identification, other information considered necessary, blah, 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 blah. Forward an abstract of the court record to the Secretary of State upon person's conviction involved in any of the following. So basically, Secretary of State should have an abstract for any traffic violation that you were part of. Okay, that was that. Department of Transportation. Just real quick. So this is again in Arizona. Department means the Department of Arizona. Director means the the director of the Department of Transportation. Department of Transportation means is the department we're talking about. The assessor of each county is an agent of the department for the purposes of this act, except unless they do something per 2006. A county assessor or director in those counties that have entered into an agreement, right? So it's either the county assessor or it's the director in counties that have entered into this agreement may establish outlets for issuance of licenses as necessary. Outlets and offices are constituted county offices of the department. And this says that the director, and the director again is the director of the Department of Transportation, and the County Board of Supervisors may contract to provide that the transfer of duties and responsibilities of the county assessor pursuant to this title to the department. So I don't know how many of those, right? The agreement shall provide for the following: the purchase and conveyance of real property presently used, the transfer and payment of personal property presently used. So, yeah, that's what the assessor does. He puts values on real and personal property. I don't know. This is saying that the Department of Transportation has taken over all of the duties of the county assessor. We're going to find out. The department assumes all the powers, duties, and responsibilities of the county assessor pursuant to this title. Okay, so I mean, it just really depends on what pursuant to this title means. Just the duties he was going to have because of this particular little thing, or all of them because of this little thing. Right, the Department of Administration shall transfer into the state service on a non-competitive basis a permanent county employee who is affected by the agreement authorized by this section and who desires to be transferred to the state employment. That's the county assessor they're talking about. Going to make the county assessor a state employee. So I guess he's taken over and taken the job with him and the duties with him to the state. Okay, and then for each certificate of title, $4. $8 to register a trailer. If it exceeds 10,000 pounds, $245. Where's the good one? For each identification plate bearing a serial or identification number to be affixed to any vehicle. It's a $5 bill, $5 for your license plate for your vehicle. Okay, but I already did a video on this whole thing, so I'm not going through the whole thing again, but we got lots more to cover. I'll get back to this stuff. Okay, so that pretty much covered the parts I wanted to cover on doing an abstract. But now let's look at the records. This is the good stuff. For instance, in Virginia, in the General District Court Manual, Record Retention, Destruction, Expungements. What did I wanted to point out? Got to read this whole thing because this has something to do about all sorts of records. But the one I was interested in, I thought caught my attention. Right here. Expungement of police and court records, adults. An action to delete all police and court reports, including electronic records, pertaining to a criminal case when any of the following has occurred: acquittal, null prosecution, I mean they didn't prosecute, dismissal, absolute pardon, an individual's name was used without consent and authorization, or case is dismissed because person arrested is not the person named on the summons, warrant, or indictment. You can have it expunged. Well, if you were in a traffic situation, because that would be a criminal case, in Virginia, and you didn't find that they had a abstract of judgment forwarded to whatever office it is in Virginia, well then, what the hell? Right? Where is the... So this is a matter of finding the court record, because unless there's something that shows that the entire case has been adjudicated, it hasn't been. So they didn't prosecute. So expunge the damn case. That's why when you go online, you're still the frickin' defendant, because the cases have never closed. They're never going to close. They won't. The only way that case can close is if they do a declaratory judgment, or they give you a jury trial and do it properly. I mean, there are ways they could do it, but pretty much they don't do these things. Right? They're not. They don't. Nobody signs any papers. Nobody completes anything. Nothing's been done. There is no sworn complaint. So in Michigan we had, you're going to want to find something like this here. All right, Administrative Rules of Court, Michigan Rules of Court 1985. We're not going to look at this because it's a little bit too hard to read, but I pulled the good parts out. So, State Court Administrator. The State Court Administrator, under the Supreme Court's supervision and direction, shall supervise and examine the administrative methods and systems employed, blah, 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 blah. The State Court Administrator is actually the Chief Judge. Now, even though we have an office called the Office of the State Court Administrator, and, they have a big office in Lansing, that isn't who they're talking about. The State Court Administrator is the Chief Judge, and we'll see why in a minute, because it's his job to administer the courts. As Director of Administration of the Court, right? This is Chief Judge Rule 8.110, Chief Judge Rule. The Supreme Court shall select a judge to serve as Chief Judge of each trial court. And then the duties. As Director of Administration of the Court, well, that would make him, the Chief Judge would be the court's administrator. A Chief Judge shall have administrative superintending power and control over the judges of the court and all court personnel with authority and responsibility to, and this is why you can write them a complaint about what's happening in the court. They have superintending control. Rule 8.105, General Duties of the Clerk. Notice of judgments, orders, and opinions. Notice of all judgments, final order, written opinion, findings filed or entered in a civil action and a court of record must be given forthwith in writing by the court clerk to the attorneys of record in the case. Right? So this again is why if you don't properly appear in the case, you're not going to get the papers. You need to file an appearance. There's another interesting one. Filing an assurance of discontinuance under something, the clerk of every judicial circuit shall without charge receive and file an assurance of discontinuance accepted by the Attorney General. Well, this has to do with Real Estate Retail Installment Sales Act. This 445870. It's like, okay, why would they make a big deal out of this in the general rules of a court and pick out something to do with retail sales? The Attorney General, or with his consent, a prosecuting attorney may accept an assurance of discontinuance of any act or practice deemed in violation of this act from any person engaging in or who is engaged in such act or practice. I wonder if they could be talking about attorneys. Because one of the things, a retail installment contract, which is part of this act is Retail Installment Sales Act. So in the definitions, what is a retail installment contract? It includes a chattel, mortgage, or security agreement. Oh, well, that sounds like a deed of trust or a mortgage, as we would call it, which is actually a security agreement. So I got to read this act some more, but basically what they're saying is, your foreclosure is going to fall within this act, and they can file an assurance of discontinuance under this. The clerk of every judicial circuit. See, now the clerk of every judicial circuit. That's different than a county circuit. This is a judicial circuit. 18th Judicial, 16th Judicial, not the Circuit Court for the County of Bay. Different thing. The clerk of every judicial circuit, without charge, receive and file an assurance of discontinuance accepted by the Attorney General under this act right here. So if somehow you get your case dismissed, I guess that's what I'm saying, is if somebody was to get their foreclosure dismissed, I think that under that maybe they've had to file this thing first. Anyway, money paid into the court. The accounts of the clerk with the banks in which the money is directed to be deposited must be kept in a single trust fund, and designation of the rights in the fund appearing on the court records. Orders to pay out funds, orders on the banks for the payment of money out of the court are made payable to the order of the persons entitled to the money or who the persons duly authorized the attorney. Now, when you go into a foreclosure, this is about the securities and so forth, and because it's an in rem proceeding, and a stakeholder was holding the property, like an escrow agent, and he's not really sure who to give it to because they never came and finished the case has never been completed, or not the case, the closing never happened. So you got this escrow agent with money in an account, and he can't give it back to anybody because he doesn't have a clear order who to give it back to. So he takes it to the court. He tells the court, here, you figure out whose property this is, and they put the money in an account. And now it's, trial by wager. Who's going to get the money that's been put in the account? You could just as easily be getting the check if we just start making the right arguments, because it's already been put in. It's an in rem hearing for property to decide whose property is it that's now in the custody and control of the court. Which is why we got to get the right records. We got to get all the records for the court case. Court reporters and recorders, what are they for? The reason given by the court for granting or refusing a motion. So this is what they do. So they're going to be in the motion hearings that we never seem to go to. Right? They're taking testimony and taking the reasons given by the court for granting or refusing any motion. Opinions and orders dictated by the court in other matters as may be prescribed by the court. So these things happen in the motion day that we're not in because we didn't get a notice to be there because you didn't put in your notice to be the attorney of record or a party of interest. They may be sending a notice to the defendant, but the defendant doesn't have your address. Right? It's that simple. When they send it to the defendant, it isn't going to come to you because the defendant doesn't have your address. And you didn't go there and put in your appearance to say, hey, anything to do in this court case, send to this address. And now, by the way, since I've put it in, I got some things I'd like to get from you, attorney of record at the other side, and you ask them for them, and they won't give it to you, well, then you can put your motion in. This sub-rule does not apply to actions tried in small claims division. Okay? And the records must remain in the physical possession of the court. So even though the court recorder does them, they stay in the possession of the court. And chief judge rule. Apart from duties of chief judge described under this rule, the chief probate judge has various obligations imposed by statute. We kind of covered this before in an earlier video, that to remove a county officer doesn't really require a judicial function. It's an executive function. It's under the governor. The governor can remove anybody from a county office. So his agent to do that, or the man doing that for him within the county, is the probate judge, the chief judge of probate. So he's the guy that you would take your complaint to have an officer of the court removed from office, such as the attorney, who is an officer of the court, always considered in court, if he won't give you the defense you're looking for. Right? You don't need to take their word for it. Say, I want you to find out where the damn arrest warrant is. Now, what they're going to want to do is they're going to say, well, I want to, they're going to want to quit. They're going to want to get removed from the case or whatever. And you don't allow, say, no, we have a contract. I want specific performance from you and a proper defense. And make him sell his fellow attorney down the river. Or the judge is going to take him out and then send the other guy down the river. So they can either both go down the river or one can go down the river. If the chief judge of probate court is not a probate judge, the senior probate judge shall serve as the chief probate judge in meeting the statutory obligations of the chief probate judge. Now, what the hell is that all about? How can the chief judge of probate not be a probate judge? I don't know. So now we're talking about the senior probate judge shall serve as the chief probate judge in meeting the statutory obligations of the chief probate judge. And those obligations are, I believe, what we're talking about here is when you have a complaint about somebody who's a county officer, or at least commissioned at a county level, and apparently that's what they do with attorneys. We'll be looking at that again here in a bit, so we'll look at it again. Local court rules, administrative orders. The trial court may adopt rules regulating practice in that court if the rules are not in conflict with these rules and regulate matters not covered by these rules, such as requires an attorney or litigant to do some act in relation to practice before that court. So in other words, there could be local court rules that you have to follow, and if you don't follow them, they're not going to pay any attention to you. So you need to ask if there's local court rules for putting in your appearance, local court rules for putting in a motion. What local court rules do you have? I'd like to have a copy of them, please. And your administrative orders. Request for investigation of courts. A request for investigation of a court may be submitted to the state court administrator. Now, who is that? That is the chief judge. Actions by a state court administrator, chief judge. The state court administrator, the chief judge, may attempt to informally resolve the dispute, inform the complainant that the investigation pursuant to this rule is not appropriate under the circumstances, direct the complainant to the Judicial Tenure Commission or the Attorney Grievance Commission, request an investigation, right, blah, blah, blah. Complainant. We'll visit that again in a minute. But there's certain things he can do, and the question is, right, submission of a request. So this is a verified complaint to the chief judge of the court that you're dealing with, if it has something to do with that court, or to the chief judge. Now again, the chief judge is appointed by the Supreme Court. Did I cover that up here? Go back to the top real quick. The Supreme Court shall select a judge to serve as chief judge of each trial court. Right? Each trial court. So the circuit court's a trial court, the district court's a trial court, the probate court's a trial court. Those are all trial courts. The Supreme Court's going to select a judge to sit as the chief judge. And that chief judge then is the director of administration of the court. He is the court administrator. Now, he may have a court administrator working for him to cover the administrative parts that he can't handle by himself because he's got to run the court also. But ultimately, he's responsible for the administration of the court. He is the court administrator. Okay, so we're taking a complaint to him. Verified complaint, sworn complaint. There is no appeal from a review of any action taken by the state court administrator under this rule, but nothing in this rule limits the right of any person to request an investigation by the Judicial Tenure Commission, Attorney Grievance Commission, or to file an action of superintendent control to the appropriate court. So you can just ask them to, you can also file for a superintendent control. Sessions of court. Except as otherwise provided by statute, a court may not limit access by the public to court proceedings unless a party has filed a written motion. And again, if you're not an attorney of record or filed your appearance into a court case, you're not going to know that these motions have happened. So the other side can file for a motion to say, hey, we want to keep you out of court. We want to shut the doors. And if nobody, if it's not a controversy, right, then boom, they can do it. That's what's happening with Dean Clifford up in Canada, right? There's nobody there who's putting in a fucking appearance for him, or he hasn't put in an appearance, so he's not getting the stuff to know when these motions are. So somebody's filed a motion into the case to close the doors to the court case, and they're not going to let anybody in. Nobody's complained about it. Okay, this goes back to those complaints now. Rule 8117, case classification codes. Please pay attention. The use of case type codes as required by MCR yada. The plaintiff must assign one case type code from the list provided by the state court administrator according to the principal subject matter of the action, not the nature of the proceeding, and include this code in the caption of the complaint. If you don't put the code in the complaint as part of the complaint, they're not going to see it. The case code must be included in the caption of all papers thereafter filed in the case. Let's look at that real quick. What are those? That's these right here. These right here. Circuit Court Case Type Code List. Appeals. This one I want. Administrative Review, Superintending Control, Extraordinary Writs. Habeas Corpus, AH. Licensing of Vehicles, AL. Superintending Control, AS. Writs, AW. All actions for a mandamus and quo warranto and other writs. So that's what you would put, those letters, AW, apparently. AH for writ of habeas corpus. All writs of habeas corpus except habeas corpus to obtain custody of a child. Well, I want to work in that one. I want a habeas corpus to take custody of my child, Robert Allen Rytlewski. So this goes on and on and on. So where do you get this from? Well, they have a list, right? These are all the different lists, and you're supposed to put this on your complaint. And so if you're complaining to the chief judge about something that's happened, then it's probably superintending control, or writ of mandamus, or writ of quo warranto that you want to put in. To satisfy Rule 8117. Include this code in the caption of the complaint. Right? So put the two letters in. And then in the caption from then on, they usually add those letters as maybe part of the court case, but I just have them separate anyways, just like it says. The case code must be included in the caption of all papers thereafter filed in the case. Everything you put it in. Right? If you're putting anything else under superintendent control, everything's got AS on it in the caption. AS. Superintendent control. AS. Tell them what it is. Ask the law clerk. Ask somebody, how exactly do you want me to put this AS? It's a procedural issue. It's your procedure. Trying to follow your procedure. It's not legal advice. Where do you want the AS at? Okay, court records and reports. So, applicability. Okay, so I haven't looked at these yet, but I will. Record standards. The clerk of the court shall comply. Right? They shall comply with MCR 1.109 and otherwise prescribed by Michigan Supreme Court. So I need to look at that. MCR 1, Michigan Court Rule, the ones I believe are from the Supreme Court. But nevertheless, in this particular group, filing of documents and other materials, the clerk of the court shall endorse on the first page of every document the date on which it was filed. And it has to follow these things: standards, legibility, captioning. All right, we just talked about captioning for a second. They got some other rules you got to follow. Okay, records kept by the clerk of the court. Pay attention now. The clerk of the court shall keep the following case records in accordance with Michigan Supreme Court records, the standards, and local court plans. Indexes and case files, except for civil infractions. And civil infractions are the other half of what a traffic ticket's used for. Misdemeanors with times less than 90 days, basically, or possible misdemeanors, which again they have to either sign the damn thing, or if it's electronic, have their full name on it. So except for those, the clerk shall keep and maintain records of each case consisting of a numeric index, an alphabetical index, a register of actions, and a case file. You see the word docket there anywhere? Say I got to keep a docket? I don't see where it says I got to keep a docket. What's a docket? They don't need to keep a docket. They got to keep a numeric index, an alphabetical index, a register of actions, and a case file. No docket. Go figure. Numeric index, alphabetical index, those are pretty self-explanatory. Register of actions. The clerk shall keep a case history of each case known as register of actions. Shall contain both pre and post judgment information. Blah, 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 blah. The offense, the judge, the fees, the dates, yada, yada, yada. And a case file. The clerk of the court shall maintain a paper or electronic file of for each action bearing the case number assigned to it, in which the clerk shall keep all pleadings, process, written opinions, findings, orders, judgments filed in the action. That's the case file. Right? All pleadings, process, written opinions, processes, warrants, writs, things like that. That's the process. All that stuff has to be in there. Right? Are you getting that in what you're asking for? No, you're going and asking for the docket. I want the docket entries. They don't have a fucking docket. Abolished record. Oh, look at that, dockets. A register of actions replaces a docket. We don't use dockets anymore. They're called register of actions. So if you go and ask for the docket, they don't have to give you shit. Right? You ask for the register of actions, well, that's a different story. Oh, yeah, we got that. Hell, that's in the law. There it is. Except as otherwise provided sub-rule F, only case records as defined sub-rule D are public records. Those are the ones we just talked about. Here are a few in sub-rule F, other ones that could be, but the ones that are the case file, the register of actions, the alphabetical index, and the numeric index. The clerk may not permit the case record to be taken from the court without an order of the court. The court may provide access to a public information in a register of actions through a publicly accessible website, and you can find them when you go search a register of actions. Hey, they do show up. All other public information in its case records may be provided through electronic means only upon request. You could have them email you this stuff. It's all on file. It's all, we don't need to have the hard copy. All the shit's on the computer. But you need to ask them. Say, I'd like to have access to the case file, the alphabetical index and numeric index. Right? Only upon request. Request it. Sealed records. The court must provide any interested person the opportunity to be heard concerning the sealing of the records. Any person may file a motion to set aside an order that disposes of a motion to seal a record. Right? So you can have it sealed. You can put in a motion to have it unsealed. A court may not charge an access or reproduction fee for a case record that the court is required by law or court rule to provide without charge to a person, other entity. So if you're a party to the action, they're supposed to send you this stuff. You're supposed to get it anyways, so they can't charge you for it. Okay, back to claims by clients against attorneys. Attorneys are officers of the Michigan One Court of Justice and are subject to summary jurisdiction of the court. Attorneys are officers of the court, always considered in court, and they can be charged with contempt of court. The circuit court of the county in which the attorney resides or maintains an office has jurisdiction on verified written complaint of a client, and after reasonable notice and hearing, to enter an order for the payment of money or for the performance of an act by the attorney which law and justice may require, such as giving you a proper defense, representing your best interest. All courts have like jurisdiction over similar complaints regarding matters arising from actions or proceedings in those courts, such as suing in the name of a fictitious plaintiff, not having a sworn complaint, those type of things, right? So you take your complaint to the chief judge, verified, sworn to, with the correct case type on it. Got to put that on there. All right, this has got 13 pages, so we got all sorts of courts in here. You don't have to look at all the different courts to see what there are. Whatever it is, depending on the subject matter, is what you would put into the caption of your complaint. And see how the wind blows. Electronic filing of a citation. Again, applicability. This rule applies to all civil infractions and misdemeanor actions initiated by the Michigan Uniform Law Citation or the Michigan Uniform Municipal Civil Infraction Citation. And again, these are the forms that they use for a traffic ticket. Citation, complaint, filing. A citation may be filed with the court either on paper or electronically. The filing of a citation constitutes the filing of a complaint. An electronic citation must contain all the information that it would be required for the citation filed on paper. A citation that contains the full name of the police officer or authorized local official who issued it will be deemed to have been signed pursuant to the law. Contested actions. If an electronic citation is contested, the court may decline to hear the matter until citation is signed and filed on paper. A citation that is not signed and filed on paper, when required by the court, will be dismissed with prejudice. And then magistrates. The court shall provide name and address, telephone number of each magistrate to the clerk of the district court for the district in which the magistrate serves. Might be good to know who the magistrates are if you need one to lay your complaint before. Okay, now, real quick, we're almost done here. Well, look at these register actions, right? Here's one for Michigan. Register of actions, right? Not a docket, a register of actions. It's got the defendant. Of course, defendant is surname, comma, given. That's like separation, two different names, as far as I'm concerned. Plaintiff is the state of Michigan, so they say. Here's the charges. Now, this is, see how they got these statutes? If you're from Michigan, you would say, well, that doesn't look like the compiled law, because the compiled law for that statute looks like this: 257.625. 257.625 1-A. Alright, so you would think that's probably 625 section 1 subparagraph A. That's what they're charging them with. But that isn't how they wrote it on here, right? They got this statute number. These are compiled laws out of the MCL, Michigan Compiled Laws. And whenever the Attorney General is talking about anything, he talks about the Michigan Compiled Laws Annotated, the MCLA. But that isn't what you're being charged with on a frickin' traffic ticket. It's a statute that looks the same, but that isn't the same number. You're not being charged for breaking a law. You're being charged for breaking a statute. Which is why, well, it doesn't matter. I'm not doing everything anyways. But just real quick now, just to show you. All right, so this is a much more complete, detailed description of what happened in this case than what most people would get in a docket. In fact, the way this thing is set up, if you had gotten it electronically, I could click on this parties present and find out who was there when the arraignment of the warrant. Arraignment on information, right? So this guy was charged with operation while intoxicated, and this says that there's an information involved, arraignment on information. And so, first there was a complaint, then a warrant, and then an information was created. So, lots of things happen, see? Lots and lots of stuff that if you were to look at what we would go and ask for the docket entries, you're not going to find this kind of stuff. That's that one. Yeah, look at another one real quick. This says Marion County Superior Court announces online registration of actions for immediate release. Right? This was back in 2010. So what? It wasn't that long ago. Whatever they did, they got to change the words. That's the way the Constitution's written. It's written to allow them to change the law to protect the public. Well, who the fuck's the public? It doesn't mean it's you. They're protecting somebody, but it doesn't mean it's you. And here's one for registration of actions, underage consumption, misdemeanor. I don't see any number for it. Right? So are you being charged with a local ordinance or breaking a state law? That's the thing of that one in Michigan, right? If I was being charged with breaking a state law, I should have had the MCL number with the period in it. Yeah, well, shut it down already. Don't need that one. So, anyways, case numbers, criminal, traffic, mandatory, tells who the attorneys are, date of birth, who the defendant is, the jurisdiction. Doesn't say who the complainant is. It just says what the jurisdiction is. I thought I was supposed to list the complainant, the parties. State of Minnesota versus, I guess it does, James. See here it says State of Minnesota versus James Earl Wilkinson. Then how come the defendant is Wilkinson, James Earl? Right? What is that? Make up your mind. It's one or the other. I demand it. It's my fucking name, right? It's either one or the other. And don't call me Mister. You can call me Elector. You can call me Lord. Don't call me Mister. So, anyways, these are easy enough to find. If you want to look at one, just put in Register of Actions, do a Google, and start, reading a little bit, and you'll find them. So, this one for Michigan is real quick again, just to show you. Right there's it says right on there the statute. We don't have statutes in Michigan. We got compiled laws. MCL. And they got a period. 257.625. Paragraph A, section, or paragraph 1, section A. So, whose statute is this? I don't know. They have some explaining to do. Anyways, well, hopefully we get to look at some of these. People that actually have ongoing cases will go down and get the real paperwork that goes to their case and ask for the case file and see what's been recorded and put in their frickin' appearance, right? So they can put in a motion and close the damn case and get it done with, and put a complaint into the chief judge, and all the things you can do if you read the damn rules, right? So quit listening to people talk out their ass and go read the frickin' rules. Again, in Michigan, it's administrative rules of court. Administrative rules of court. And it looks like in Virginia it could be called General District Court Manual, Record Retention, Destruction, and Expungement. Right? Things have to do with the records. What makes up a court case? It's good stuff. Okay, we're going to leave it there for tonight, and we'll see. Well, tomorrow's a holiday, so probably won't much happen in the courts and so forth, but I'll give you one more day to think about it. And then maybe get up off your ass and go put in something and see what they say instead of waiting for somebody else to figure it out for you. Be a wonderful day. Alrighty. Have a great night.